Hello and welcome to Moneylife. This is Sucheta Dalal. This week we are going to talk about something interesting, which is our judges, our Supreme Court, their disclosures, and their assets. Why should it matter to you? That's what I'm going to talk about. So, at a time when all of us were riveted on Operation Sindoor, a decision by the judges of the Supreme Court to voluntarily disclose their assets went largely unnoticed. The disclosure is a big step forward from the sporadic and minimal disclosures that our judges have been making for decades. And this is of significance to anyone who has to knock on the doors of justice. Not only does it mark a small, important step towards more transparency in India's rather opaque judicial system, but it has a special importance for investors. Let me tell you why. In a democracy, the judiciary is often the final arbiter of accountability. Yet, the Indian judiciary, which prescribes really tough disclosure laws even to elected representatives, remember their affidavits before election, do not make disclosures themselves, and they have resisted calls for disclosure and transparency going as far back as 1997, when this whole move towards transparency in various spheres of public life was beginning to happen. Efforts to legislate asset declaration were made in 2010, again in 2023, but it went nowhere. Little bits and pieces happen. Even today, an overwhelming majority of judges shield their assets from public view. Recent disclosures were also in response to the acute embarrassment caused on 14th March when a fire broke out at the home of Justice Yashwant Verma of the Delhi High Court, and a large amount of burning cash was discovered and was all over social media. We've written about it extensively. You could go to Moneylife and read about it. So, the next month, early May, the Supreme Court responded by publishing asset disclosures of several sitting judges. 21 out of 33 have complied, and it's available on the Supreme Court website with PDFs for each individual judge, which you can go and open and look at. High Courts, its transparency is still dismal. Out of 749 judges posted across 25 high courts, only 98, or rather 13%, have disclosed their assets publicly. Of these, the Kerala, Delhi, and Punjab and Haryana High Court account for 80% of disclosures. The Gujarat High Court even went so far as to argue that there's no public interest involved in such transparency. It's worth noting that back in 2009, the SC itself had resolved to make asset disclosures voluntary. But that move also led to very little compliance. Few judges did disclose. Even today, not all the judges have felt the pressure to disclose their assets. This is not how the world works. A World Bank opinion piece of 2016, which was written at a time when Ukraine was trying to beat corruption and wanting accountability and passed a law for mandatory disclosures by judges. This report at that time said 150 countries had made asset declaration mandatory for judges. Remember, final arbiter of everything. Transparency has to start over there. The report also noted that there is no worry about disclosure, public disclosure of private assets violating privacy laws, especially when weighed against the compelling public interest in detecting corruption and preventing conflict of interest. How are you to know? That's the question, right? So in 2023, the US enacted legislation mandating disclosure of investments by judges and that they should recuse themselves when there's a conflict of interest. Countries like UK, Canada, South Korea, Philippines, even Russia have codified ethical standards of judicial conduct. Some have investigation departments that look at it. Of course, the rules don't guarantee judicial purity because people have been caught violating in spite of the disclosures. But codified norms allow for action when you catch a mismatch between declared and actual wealth, something that India continues to shy away from. The disclosure by SC judges makes for interesting reading. I know most of you are not going to go and click those PDFs, so let's give you an overview. It shows a very conservative preference of investments. Most of them have their money in fixed deposits, public provident fund, general provident fund, a lot of it in real estate, some gold and jewelry. Only three judges have reported investments in shares, mutual funds, or in portfolio management schemes. Some of the shares are trivial, like Chief Justice Khanna, or Justice Bela Trivedi has 60 lakhs in mutual funds. Again, relatively small amount. Only Justice K.V. Vishwanathan has a significant portfolio of over 100 crores stemming from the days when he was a very successful lawyer. Now, does this conservatism reflect ethical concerns that judges want to avoid conflict of interest by staying clear of company shares because they're constantly listening to corporate disputes? Then stockbroking firms, mutual funds, is that why they're doing this? Possibly. But it's very clear that this is not the case every time. After all, allegations about judicial corruption have erupted repeatedly and long before Justice Verma's burnt cash case. In 2009, Prashant Bhushan, a leading civil rights lawyer, famously alleged in a media interview that half the past 16 chief justices, chief justices of the Supreme Court were corrupt. It created a furor, led to significant legal and public scrutiny. Contempt proceedings were initiated against Prashant Bhushan. This prompted his father, Shanti Bhushan, former law minister, to actually join the proceedings and submit evidence of corruption, further escalating the controversy. It used to make headlines every day. In 2022, after dragging on for a long time, the Supreme Court finally just dropped the proceedings against Mr. Bhushan, which closed the case but not the issue. In 2011, Justice P.D. Dinakaran, former Chief Justice of the Karnataka High Court, was accused of land grabbing and unaccounted wealth. He resigned before impeachment proceedings were concluded. What does this all mean? It clearly means that caution in market investments by the judiciary is not merely about ethics. It may stem from risk aversion or a fundamental distrust of India's stock markets or risk based investment. Now, this raises a deeper question. A highly decorated policymaker, now retired, raised this with me, and he asked whether judges' reluctance to touch capital market investments signals a broader lack of confidence in the entire system. Now, wouldn't that be ironic? After all, India now boasts one of the world's most sophisticated market infrastructures with demutualization of shares mandatory, near instant settlements. India's national stock exchange is one of the five biggest exchanges in the world, and in terms of derivative volumes, at one time was the largest. The number of retail investors, especially post COVID, has soared to 110 million. But judges are not impressed. India is also making vast investments in systematic investment plans of mutual funds. Our judges want none of it. From a conflict of interest standpoint, this conservatism is fantastic, it's commendable. But it also reveals a blind spot. Judges possibly even lack an understanding of capital markets. They may not grasp the complexity of rules and regulations governing disclosure, transparency, fiduciary obligations, insider trading, and the importance of deterrent penalties. In financial markets, deterrent penalties are everything because if there is such a huge penalty that it eats up the profits that you have made illegally and by dubious means, only that will prevent you from breaking the rules. And I have been pointing this out for a long time, the disconnect and the consequences. So in 2007, I wrote in the Indian Express, link is available here, that one of the biggest challenges of security regulators has been to sensitize the judiciary to the nuances of capital market regulation. I said there have been innumerable cases where the Securities Appellate Tribunal has slashed monetary penalties, making them meaningless without understanding the punitive financial damages are the only real deterrent to financial crime. This was a time when SAT even took it upon itself, very strangely, to determine whether the stigma of wrongdoing should attach to an individual indicted for insider trading. I mean, think about this. Somebody has been indicted for insider trading, it's proven, and SAT is worried about the stigma attached to this wrongdoer. It is an action that called into question the very basis of insider trading regulation and market manipulation. But that was the level of ignorance. To my mind, it continues. In 2021, I had again talked about this. In fact, this time it goes up all the way to the Supreme Court. And I had said the Supreme Court failed to grasp the significance of exemplary penalties on credit rating agencies. Remember 2021, 2018, you had a series of failures from ILFS to Diwan Housing. In each case, the rating agencies had a AAA rating for these companies right until they collapsed. Okay. And this had debilitating losses for investors, homeowners, creditors of all kinds, especially those who are not secured, but secured creditors as well. And this had gone to the Supreme Court after SAT had reduced the penalty imposed by the market regulator SEBI, but SC dismissed its appeal. In fact, the judgment, as I said, effectively told investors trust ratings at your own risk and don't expect rating agencies to face any consequences when they fail in their fiduciary duties. In other words, failure to grasp the stringency needed to deal with financial misdemeanors can mean judicial indulgence towards speculators, delinquent corporates, compromised auditors, and negligent rating agencies. Think about it for a moment. All these stakeholders that I'm talking about, whether it's large speculators, delinquent corporates, compromised auditors, go to the Supreme Court with the best lawyers. They make strong legal arguments. And if your judiciary does not understand why they need to be punished, what is the meaning of fiduciary duty, what is the meaning of people depending on what a statutory auditor says or a rating agency says, then look at how big are the losses for investors or funds or anybody who trusts in the system. Judges who don't understand markets may also fail to grasp why fiduciary actors like regulators, for instance, the chairperson of the Securities and Exchange Board of India, must meet a far higher standard of transparency and disclosure than regulated entities. I mean, this issue is going to climb up to the Supreme Court, where who signed what is also going to matter, and why it matters more with regard to a person who's a regulator than a regulated entity is something that a enlightened judiciary who understands market disclosure and transparency and fiduciary responsibilities should know. Avoiding capital markets is a personal choice. You don't like the risk, don't invest. But ignorance of how capital markets functions is not an option, especially for those charged with interpreting the laws that govern them. India urgently needs a large pool of judges who understand securities laws and financial regulation. Today, the number of those who do can be counted on the fingers of one hand. Unless courts appreciate the fundamental purpose of deterrent penalties, transparent enforcement, and institutional accountability, India will continue to oscillate between regulatory overreach and judicial underreach. And the casualty is investor confidence. Do we want that? This is how disclosures, which may seem unrelated to you, may actually affect you as an investor. If you agree, please share this, because until more people think about this, nothing is going to change. Thank you.